The smell of old paper and betrayal filled the law office as Attorney Henderson slid the inheritance documents across his mahogany desk. My hands trembled as I read the words that would haunt me for the next 2 years. Due to incomplete documentation, the estate distribution cannot proceed as originally intended. One missing signature on a family trust amendment had just cost me my rightful share of my grandfather's $4.6 million estate. And the person responsible sat across the conference table with a smug smile that made my blood boil. "I'm sorry, Daniel," said my cousin Victoria Ashford, her voice dripping with fake sympathy. "Grandfather's wishes were very clear. The trust requires all amendments to be witnessed and notarized. Since the codicil adding your additional inheritance wasn't properly executed, the original distribution stands. The original distribution that gave Victoria 60% of the estate while I received 40%, despite being the one who'd cared for grandfather Edmund during his final 5 years. Despite being the one who'd moved back to Millfield to manage his business affairs when dementia started affecting his judgment. Despite being the grandson he'd specifically told me would inherit the lion's share for your devotion and sacrifice. At 34, I'd given up my engineering career in Seattle to become Edmund Ashford's full-time caregiver and business manager. The pharmaceutical patents that formed the core of his wealth required constant attention, licensing negotiations, and legal oversight that Victoria, busy with her Manhattan law practice, couldn't be bothered with until inheritance time arrived. The missing signature belonged to Dr. Marcus Webb, grandfather's longtime physician and family friend, who'd witnessed Edmund sign the trust amendment in his hospital room 3 months before his death. The amendment that would have given me 65% of the estate in recognition of my years of sacrifice and dedication. But Dr. Webb had died in a car accident 2 weeks after witnessing the signing, before he could return to the law office to complete the notarization process. A bureaucratic technicality that invalidated the document and cost me $2.3 million. "The law is clear," Victoria continued, adjusting her designer glasses with perfectly manicured fingers. "Without proper notarization, the amendment has no legal standing. The original trust distribution remains in effect." Attorney Henderson nodded reluctantly. "I'm afraid Mrs. Ashford is correct. While your grandfather's intentions seem clear from the amendment's content, Florida probate law requires strict compliance with execution formalities. Without Dr. Webb's notarized signature, we cannot validate the document." I stared at the amendment, written in grandfather's increasingly shaky handwriting. "Daniel has been my devoted caregiver and business partner. His sacrifice deserves greater recognition. I hereby amend the trust to reflect his true contribution to our family's legacy." The words were authentic. The signature was authentic. Even Victoria couldn't dispute that Edmund had intended to increase my inheritance. But one missing bureaucratic step had handed her an extra $2.3 million while reducing my share by the same amount. "Daniel, I hope you understand this isn't personal," Victoria said, packing expensive legal documents into her Louis Vuitton briefcase. "I'm simply following grandfather's legally valid instructions." His legally valid instructions from 2018, before I spent 5 years managing his care and business affairs. Before he repeatedly told me I'd be the primary beneficiary because of my devotion. Unfortunately, intentions don't override legal requirements. Perhaps grandfather should have been more careful with his paperwork. The casual cruelty of that comment revealed everything I needed to know about my cousin's character. She'd watched me sacrifice my career, my relationships, and my future to care for our grandfather, then swooped in to claim the majority of his wealth based on a technicality that prevented his true wishes from being honored. That evening, I sat in grandfather's study, surrounded by 5 years of memories and the bitter taste of injustice. The pharmaceutical patent files I'd meticulously organized covered every surface, representing millions in ongoing royalty income that Victoria would now control despite having no understanding of the science or business relationships involved. The irony was suffocating. I'd protected Edmund's intellectual property, negotiated licensing agreements, and managed his investment portfolio with the dedication of someone who expected to inherit the responsibility along with the reward. Instead, Victoria would receive control of assets she'd never bothered to understand, while I got a minority stake in wealth I'd helped preserve. But as I reviewed the trust documents one more time, something caught my attention. A detail so subtle that even Henderson's law firm had missed it during their initial review. The original 2018 trust contained language about future amendments and modifications as circumstances warrant, with specific provisions for how changes should be implemented and validated. Buried in Section 12.3 was a clause I'd never noticed before. In cases where witness unavailability prevents standard notarization procedures, alternative validation methods may be utilized, including video documentation, medical records corroboration, or testimony from additional family members present during execution. My pulse quickened as I remembered something Victoria didn't know about. Something that could change everything. The day grandfather signed the amendment, I'd been recording our conversation with my phone to help him remember medical instructions later. The entire signing process was captured on video, including Dr. Webb's verbal confirmation of Edmund's mental competency and his promise to complete the notarization process. More importantly, grandfather's home health nurse, Margaret Santos, had been present during the signing and had made notes in his medical file about the legal document he'd executed that day. Her records could provide the corroborating evidence needed to validate the amendment under the trust's alternative procedures. Victoria thought she'd won through legal technicalities, but she'd underestimated the thoroughness of someone who'd spent 5 years documenting every aspect of Edmund's care. Every conversation, every medical appointment, every legal consultation had been carefully recorded and filed. I pulled out my phone and scrolled through the videos from that day. The image quality was clear, the audio perfect. Edmund's voice, strong despite his illness. "Daniel, you've earned this. Your dedication deserves proper recognition. I'm changing the trust to give you the majority share you've earned through your sacrifice." Dr. Webb's voice confirming Edmund's mental competency. "Mr. Ashford is lucid and understands the legal implications of this amendment. I'll complete the notarization process when I return to my office." Margaret's voice documenting the signing for medical records. "Patient executed legal trust amendment today with full understanding of contents and implications. Witnessed by Dr. Webb and myself. Patient expressed satisfaction with estate planning decisions." The video evidence was compelling, but I needed more. Legal battles require overwhelming proof, not just strong evidence. Victoria had expensive attorneys and would fight viciously to protect her windfall. Over the next week, I gathered additional documentation. Margaret's detailed nursing notes included multiple references to Edmund's estate planning activities and his expressed satisfaction with decisions that would properly reward Daniel's devotion. Medical records from Dr. Webb's office contained appointment summaries mentioning the trust amendment and the doctor's role as witness. Most importantly, I found correspondence between Edmund and Attorney Henderson discussing the planned amendment and the reasons behind it. Email chains spanning several months showed my grandfather's consistent intention to increase my inheritance in recognition of my caretaking role. The evidence painted a clear picture of Edmund's true wishes, even if bureaucratic technicalities had prevented proper legal execution. But Victoria had already begun liquidating estate assets, selling investments and transferring funds as if the matter were settled. When I requested an emergency hearing to present new evidence, her response revealed the depths of her desperation to protect her ill-gotten gains. The woman who'd claimed this wasn't personal was about to show me just how personal greed could become. The real war for my grandfather's legacy was about to begin. The conference room at Henderson and Associates felt different this time. Instead of Victoria's smug confidence, I sensed desperation barely masked by expensive perfume and aggressive posturing. She'd brought 2 additional attorneys, a clear sign that my request for an emergency hearing had rattled her more than expected. "Mr. Ashford's claims are frivolous," declared her lead counsel, Robert Manning, whose $800 hourly rate was evident in every syllable. "Florida probate law doesn't recognize alternative validation methods for trust amendments. The missing notarization invalidates the document. Period." I opened my laptop and activated the projector I'd requested. "Your Honor, I'd like to present evidence that the trust's own language provides for alternative validation in exactly these circumstances." The video began playing, showing grandfather Edmund in his hospital bed, alert and determined despite his illness. His voice filled the room. "Daniel, You've been more than a grandson. You've been my partner, my caregiver, and my closest family member during these difficult years. This amendment ensures you receive the inheritance you've earned." Victoria's face went pale as she watched her grandfather's authentic words, recorded just 3 months before his death. The contrast between his genuine affection for me and her opportunistic legal maneuvering was stark and uncomfortable. "This video proves Edmund's intentions," I continued, "but more importantly, it documents proper witnessing procedures under the trust's alternative validation provisions." I displayed section 12.3 on the screen, highlighting the specific language about video documentation and medical record corroboration. Dr. Webb's verbal confirmation of competency, combined with Nurse Santos's contemporaneous medical notes, satisfies the trust's requirements for alternative validation when standard notarization is impossible. Judge Patricia Morrison studied the trust language carefully. "Mr. Manning, how do you respond to the alternative validation clause?" "Your Honor, that provision was intended for minor procedural issues, not fundamental execution failures. The amendment lacks the formal structure required for major estate modifications." But I was ready for that argument. I'd spent weeks researching similar cases and had found precedents in 3 other states where video evidence and medical corroboration had validated disputed testamentary documents. "Your Honor, I'd also like to present correspondence between my grandfather and Attorney Henderson discussing this specific amendment and the reasons behind it." The email chain painted a compelling picture of Edmund's deliberate, well-considered decision to increase my inheritance. His messages to Henderson detailed my sacrifices, my business contributions, and his desire to ensure Daniel receives proper compensation for his devotion. Victoria's attorney objected strenuously, but Judge Morrison allowed the emails into evidence. The pattern of communications showed Edmund's consistent intention over several months, undermining any argument about confused or impulsive decision-making. "Additionally," I said, "Nurse Santos's medical records document my grandfather's repeated statements about estate planning decisions and his satisfaction with arrangements that would reward Daniel appropriately." Margaret Santos had been thorough in her documentation, recording Edmund's discussions about the trust amendment and his expressed pleasure with decisions that recognized my contributions. Her nursing notes provided the medical record corroboration required by the trust's alternative validation provisions. But the smoking gun came from an unexpected source. While researching Edmund's final months, I discovered he'd been working with a financial advisor to restructure his investment portfolio in preparation for the new estate distribution. "Your Honor, these investment modifications were made specifically to accommodate the amended trust distribution. My grandfather repositioned assets to ensure smooth transition under the new inheritance structure, providing additional evidence of his genuine intention to increase my share." The financial advisor's records showed Edmund had liquidated certain investments and restructured others to create more liquid assets for the anticipated 65% distribution to me. These changes made no sense under the original trust terms but were logical preparation for the amended distribution. Victoria's composure cracked completely. "This is all speculation and manipulation. Grandfather was mentally compromised during his final months, and Daniel took advantage of his confusion to obtain these supposed amendments." Her outburst backfired spectacularly. Judge Morrison's expression hardened as Victoria essentially accused me of elder abuse without evidence, while simultaneously contradicting her own legal position that Edmund was competent enough to execute valid legal documents. "Mrs. Ashford, are you claiming your grandfather lacked mental capacity during the relevant period?" Victoria's attorneys exchanged panicked glances. If they argued Edmund was incompetent, it would invalidate not just the amendment but potentially the entire trust. If they maintained he was competent, they couldn't explain away the extensive evidence of his intention to modify the distribution. "Your Honor," Manning stammered, "our position is that Mr. Ashford was competent, but that the amendment was improperly executed due to procedural deficiencies." Then explain the video evidence, medical records, attorney correspondence, and financial planning activities all supporting his intention to increase Daniel's inheritance. The silence was deafening. Victoria's legal team had no answer because there wasn't one. The evidence overwhelmingly supported Edmund's desire to amend the trust, and the trust's own language provided mechanisms for validating amendments when standard procedures were impossible. Judge Morrison requested a 48-hour recess to review all evidence and research relevant precedents. As the hearing adjourned, Victoria approached me with barely controlled fury. "You think you're clever, don't you? Manufacturing evidence and manipulating a sick old man's final months to steal money that rightfully belongs to me." "Victoria, I didn't manufacture anything. I documented everything because I cared about grandfather's well-being and wanted to honor his wishes. You're the one trying to steal money through legal technicalities. We'll see about that. I have resources you can't imagine, and I won't let some small-town mechanic-turned-caregiver steal my inheritance." Her threat revealed everything I needed to know about her character and her plans. If she couldn't win through legitimate legal arguments, she'd try intimidation, harassment, and whatever other tactics her expensive attorneys could devise. That evening, I received the first sign of Victoria's escalation campaign. A certified letter from Manning's law firm demanded I cease making defamatory statements about Mrs. Ashford's character and motivations, and threatened a $500,000 lawsuit for intentional interference with inheritance rights. The legal threat was almost comical since everything I'd presented in court was documented evidence, not defamatory opinion. But it revealed Victoria's strategy: use expensive legal harassment to exhaust my resources and force a settlement that would preserve most of her windfall. The next morning brought a private investigator to my door, asking neighbors about my relationship with elderly clients and my financial motivations for providing caregiving services. Victoria was building a case that I'd manipulated Edmund for financial gain, despite overwhelming evidence of my legitimate devotion and his authentic gratitude. But her desperate tactics were about to backfire in ways she never anticipated. The investigation she'd commissioned would uncover evidence that supported my case while revealing her own questionable behavior during Edmund's final months. Sometimes the best defense against expensive attorneys and harassment campaigns is simply letting the truth speak for itself. And the truth about Victoria's relationship with our grandfather was about to become very uncomfortable for her legal position. The private investigator Victoria hired made his first critical mistake on Wednesday morning. Instead of simply asking neighbors about my character, he started inquiring about Edmund's mental state during his final months, and whether I'd isolated him from other family members. Mrs. Eleanor Hutchins, Edmund's next-door neighbor for 23 years, called me immediately after the investigator left her doorstep. "Daniel, that man was asking very strange questions about your grandfather's visitors and whether you controlled who could see him. I told him Edmund was sharp as a tack until the very end, and that you encouraged family visits that certain people were too busy to make." The investigator's questions revealed Victoria's desperation strategy: paint me as a manipulative caregiver who isolated Edmund from family to control his estate decisions. But this approach would require proving I'd restricted access to someone who'd received constant medical and social supervision from multiple healthcare providers. "Mrs. Hutchins, do you remember Victoria visiting during grandfather's final year?" "Honey, I saw that woman maybe 3 times in the last 2 years. Always in her fancy car, always in a hurry. You were there every day, managing his care, handling his business, making sure he had everything he needed." The investigators' inquiries had inadvertently gathered evidence supporting my case while undermining Victoria's credibility. If she wanted to argue that Edmund was vulnerable to manipulation, she'd have to explain why she hadn't been present to protect him from alleged abuse. But her harassment campaign escalated quickly. Thursday brought a surprise visit from Adult Protective Services, claiming they'd received reports of financial exploitation of an elderly person and needed to investigate my caregiving relationship with Edmund. The APS investigator, Maria Rodriguez, was professional but thorough. "Mr. Ashford, we've received allegations that you may have taken advantage of your grandfather's diminished capacity to obtain financial benefits. Can you walk me through your caregiving arrangement and any financial transactions?" I provided comprehensive documentation of my care for Edmund: medical appointments, prescription management, physical therapy sessions, business correspondence, and financial records showing my careful stewardship of his assets. The evidence painted a picture of devoted care rather than exploitation. Ms. Rodriguez, my grandfather's cognitive function was regularly assessed by his medical team. Dr. Webb, his neurologist Dr. Chun, and his psychiatrist Dr. Morrison all documented his mental competency throughout his final years. I can provide those records if needed. What about the trust amendment that's currently in dispute? I showed her the video documentation, medical records, and correspondence proving Edmund's deliberate decision-making process. He spent months planning this amendment, discussing it with his attorney, restructuring his investments to accommodate it. This wasn't an impulsive decision by someone with diminished capacity. Maria's expression shifted from investigation to sympathy as the evidence mounted. Mr. Ashford, this appears to be a family dispute over inheritance rather than elder abuse. The documentation you've provided shows appropriate care and respect for your grandfather's autonomy. After she left, I realized Victoria's harassment campaign was generating evidence that supported my case. Every investigation revealed the depth of my care for Edmund and the absence of any exploitation or manipulation. But the most damaging revelation came from an unexpected source. While reviewing Edmund's phone records for evidence of social isolation, I discovered something Victoria hadn't considered: her own recorded conversations with our grandfather during his final months. Edmund had been using a medical alert system that recorded calls for quality assurance and emergency response purposes. The recordings captured several conversations between Edmund and Victoria that revealed her true priorities and motivations. In one particularly damaging conversation from 2 months before his death, Victoria's voice was clear. "Grandfather, you need to be careful about changing legal documents when you're not feeling well. Daniel might be taking advantage of your condition to get more inheritance money." Edmund's response was sharp and lucid. "Victoria, Daniel has earned every penny he'll receive. He's sacrificed his career and his personal life to care for me. Your concern about his inheritance seems motivated by your own financial interests rather than my well-being." "Victoria, I'm just saying the family would be upset if the estate distribution changed dramatically based on recent decisions." "Edmund, the family consists of you and Daniel. He's here every day managing my care and my business. You visit when it's convenient for your schedule. The estate distribution will reflect that reality." The recordings demolished Victoria's legal strategy. Instead of showing my manipulation of a vulnerable elder, they revealed her attempts to influence Edmund's estate decisions while contributing nothing to his care or well-being. Armed with this evidence, I requested an emergency conference with Judge Morrison. Victoria's attorneys looked increasingly uncomfortable as I presented the recorded conversations, APS investigation results, and neighbor testimonies gathered by her own private investigator. "Your Honor, these recordings demonstrate that Mrs. Ashford was the family member attempting to influence my grandfather's estate decisions, while simultaneously accusing me of the manipulation she was actually perpetrating." Judge Morrison listened to the recordings with obvious displeasure. Victoria's voice coaching Edmund against changing his estate plans while providing no caregiving support contrasted sharply with Edmund's clear, competent responses defending his decisions. "Mrs. Ashford," the judge said sternly, "these recordings suggest you were attempting to influence your grandfather's testamentary decisions while accusing your cousin of the same behavior. How do you explain this contradiction?" Victoria's composure cracked completely. "I was concerned about grandfather's well-being. Daniel had isolated him from family and was pressuring him to change the trust. The evidence suggests the opposite. Your cousin documented extensive medical supervision, regular family communication, and transparent financial management. Meanwhile, you appear to have visited rarely while attempting to influence estate decisions when you did visit." Manning tried to salvage the situation. "Your Honor, our client's concern for her grandfather's welfare demonstrates her genuine care for his best interests." "Mr. Manning, the recordings suggest Mrs. Ashford's concerns were primarily financial. Her grandfather explicitly stated that the estate distribution should reflect actual caregiving contributions, not convenient legal technicalities." The hearing's momentum had shifted completely. What began as Victoria's attempt to invalidate the amendment through harassment and investigation had backfired, generating overwhelming evidence of Edmund's mental competency, my appropriate care, and her opportunistic behavior. Judge Morrison's preliminary ruling came Friday afternoon. Based on the video evidence, medical documentation, attorney correspondence, financial planning records, and recorded conversations presented by Mr. Daniel Ashford. This court finds compelling evidence that Edmund Ashford intended to modify his trust distribution to reflect his grandson's caregiving contributions. Furthermore, the trust document's alternative validation provisions appear to be satisfied by the comprehensive evidence presented. The court will issue a final ruling within 10 days, but preliminary indication supports recognition of the disputed amendment. Victoria's legal team immediately filed notice of appeal, but the damage was done. Her harassment campaign had generated evidence supporting my case while revealing her own questionable motivations and behavior. That evening, I sat in Edmund's study, surrounded by 5 years of memories and the growing certainty that justice would prevail. The pharmaceutical patents would remain under my stewardship. The investment portfolio would be managed by someone who understood Edmund's vision, and his true wishes would be honored despite bureaucratic technicalities. But Victoria's desperation hadn't peaked yet. Appeals court battles can take years, and she had the resources to drag out litigation until my legal costs forced a settlement. Her final gambit would test everything I'd learned about fighting expensive attorneys with truth, documentation, and unwavering determination to honor my grandfather's legacy. The appellate court brief landed on my doorstep like a 200-page declaration of war. Victoria's legal team had crafted a masterpiece of expensive legal argumentation, challenging everything from the trust's alternative validation provisions to the admissibility of recorded phone conversations as evidence of testamentary intent. Manning's strategy was brutal in its simplicity. Drag out the litigation until my resources were exhausted, then offer a settlement that gave Victoria the majority of the estate while throwing me enough money to make continued fighting seem foolish. The appeal process would take 18 to 24 months, during which time estate assets would remain frozen while legal fees mounted exponentially. "Daniel, I have to be honest with you," said my attorney, Sarah Chun, reviewing the appellate brief in her modest office. "Fighting this appeal will cost at least $150,000, possibly more if they drag it out with multiple motions and procedural challenges. Victoria's team is betting you can't afford a prolonged battle." The math was sobering. My savings from 5 years of managing Edmund's business affairs totaled about $180,000, enough to fund the legal battle if I was willing to risk everything. If I lost the appeal, I'd be broke and still stuck with the original trust distribution that gave me 40% instead of 65%. "Sarah, what are our chances on appeal?" "Honestly, about 70% based on the evidence we presented. But appellate courts focus on legal procedure rather than factual merit. Victoria's team is arguing that Judge Morrison exceeded his authority by accepting alternative validation methods not explicitly recognized in Florida probate statute. That evening, I faced the hardest decision of my life. Risk everything in a legal battle I was likely to win, or accept Victoria's settlement offer. A 50-50 split that would give me $2.3 million instead of the $3 million I deserved, while saving legal costs and ending the conflict. The settlement offer was generous enough to seem reasonable while preserving most of Victoria's windfall. She'd still receive $200,000 more than she deserved, but I'd avoid the risk of losing everything in appellate court. But as I sat in Edmund's study, surrounded by 5 years of memories and sacrifice, I heard his voice from that hospital room video. "Daniel, you've earned this. Your dedication deserves proper recognition." I called Sarah at 7 a.m. Friday morning. "File the appellate response. We're fighting this to the end." The next 6 months were a masterclass in expensive legal warfare. Victoria's team filed motion after motion, challenging every piece of evidence, every procedural decision, every legal precedent we cited. Each motion required detailed responses that cost thousands in attorney fees and consumed weeks of time. But their aggressive strategy created unexpected opportunities. The more they attacked the evidence of Edmund's mental competency and deliberate decision-making, the more they highlighted the strength of our documentation and the weakness of their position. The breakthrough came from an unlikely source. While researching similar cases for our appellate brief, Sarah discovered that Florida's 3rd District Court of Appeal had recently ruled in estate of Rodriguez versus Rodriguez, establishing precedent for exactly the alternative validation methods we'd used. "Daniel, this changes everything. Rodriguez involved nearly identical circumstances, a trust amendment witnessed but not notarized before the witness died. The appellate court ruled that comprehensive alternative evidence could validate the amendment under the trust's own provisions. The Rodriguez decision had been issued just 3 months earlier, after Victoria's team filed their appeal. Our supplemental brief citing this precedent would be devastating to their legal arguments. But Victoria wasn't finished. Her next move revealed the depths of her desperation and the resources she was willing to commit to protecting her inheritance windfall. I woke up Tuesday morning to find my car's windshield shattered and "thief" spray painted across my garage door in red letters that dripped like blood. The vandalism was obviously intended to intimidate me into abandoning the legal battle, but it also provided evidence of Victoria's escalating harassment campaign. The security footage from my neighbor's camera captured the vandalism, showing 2 figures in dark hoodies deliberately targeting my property. While their faces weren't visible, one of them walked with a distinctive limp I'd noticed when Victoria's husband, Richard, had struggled with heavy luggage during their last visit to Edmund's funeral. Sarah, I think Victoria's harassment has crossed into criminal territory. When I filed a police report, Officer Martinez took the incident seriously. Mr. Ashford, this appears to be intimidation related to your inheritance dispute. We'll investigate, but you should consider that someone willing to commit vandalism might escalate to more serious crimes if they feel desperate enough. That same week brought another escalation. A certified letter from Manning's firm accused me of elder abuse, financial exploitation, and fraudulent manipulation of testamentary documents, and threatened to file criminal charges if I didn't withdraw the appeal and accept the previous settlement offer. The criminal threat was legally meaningless since I'd been investigated by Adult Protective Services and cleared of any wrongdoing. But it revealed Victoria's growing panic as our appellate brief citing Rodriguez gained momentum with the court. The final showdown came during oral arguments before the 3rd District Court of Appeal. The courtroom was packed with attorneys from both sides, legal observers interested in a state law precedent, and family members ready to witness the resolution of 2 years of bitter litigation. Victoria sat in the front row wearing a black suit that probably cost more than most people's monthly salary, her expression mixing confidence with barely controlled anxiety. She'd committed enormous resources to this battle and knew that losing would cost her not just money but credibility with the legal community she worked within. Manning's presentation was masterful, challenging every aspect of our case with expensive eloquence and procedural sophistication. Your Honors, accepting Mr. Ashford's alternative validation theory would undermine fundamental probate law protections against fraudulent or inadequately documented testamentary changes. But Sarah's response was devastating in its simplicity. Your Honors, the Rodriguez decision establishes clear precedent for this exact situation. When a trust document provides alternative validation procedures and comprehensive evidence supports the decedent's testamentary intent, procedural technicalities cannot override substantive justice. Judge Catherine Morrison, no relation to our trial judge, asked the crucial question, "Counselor, what distinguishes this case from Rodriguez?" Sarah smiled confidently. "Nothing, Your Honor. Both cases involve trust amendments witnessed but not notarized due to witness death. Both involve comprehensive alternative evidence of testamentary intent. Both involve trust documents that specifically provide for alternative validation methods. Rodriguez establishes that such evidence can validate disputed amendments." The silence in the courtroom was deafening. Manning had no response because Rodriguez had indeed established exactly the precedent we needed. Victoria's expensive legal strategy had been undermined by a case decided after her appeal was filed. The court's decision came 6 weeks later. The judgment of the trial court is affirmed. The evidence presented satisfies the trust document's alternative validation provisions, and the Rodriguez precedent supports recognition of the disputed amendment despite notarization deficiencies. Victoria had lost everything. The appellate court's decision meant I would receive 65% of Edmund's estate as he intended, while her share dropped to 35%. More importantly, the precedent would make it nearly impossible for her to pursue further appeals. The final irony came 3 months later when Victoria's law firm sued her for unpaid legal fees exceeding $400,000. Her battle to steal my inheritance had cost her more money than she would have lost by accepting Edmund's original intentions. But the real victory wasn't financial. It was honoring my grandfather's wishes and proving that truth and documentation could triumph over expensive legal manipulation. Edmund's pharmaceutical patents would remain under the stewardship of someone who understood his vision, and his estate would be distributed according to his genuine intentions rather than bureaucratic technicalities. 6 months after the appellate victory, I established the Edmund Ashford Foundation for Alzheimer's Research, using a portion of my inheritance to fund the kind of medical research that might have helped my grandfather live longer. The foundation's first grant went to Dr. Marcus Webb Memorial Research Fund, honoring the physician whose death had created the legal technicality that nearly cost me everything. If you're facing inheritance disputes based on missing documents or procedural technicalities, remember this: comprehensive documentation, alternative evidence, and persistence can overcome expensive legal tactics. Your loved one's true intentions matter more than bureaucratic formalities, and truth has a way of prevailing when presented with patience and determination. Sometimes the best way to honor family legacy is to fight like hell for justice, even when the odds seem impossible and the costs seem overwhelming. The sound of victory tastes sweeter when you know you've earned it through dedication, sacrifice, and unwavering commitment to doing what's right. Edmund Ashford's legacy lives on not just in the inheritance he left behind, but in the precedent his case established for protecting family intentions against legal technicalities. One missing signature cost me 2 years of battle, but it couldn't steal the justice my grandfather intended me to receive. 2 years later, I wake up in Edmund's old study, now converted into the foundation office where his legacy lives on through medical research funding. The morning sun streams through windows that once framed our conversations about business, family, and the importance of doing what's right regardless of personal cost. The pharmaceutical patents that Victoria tried to control through legal technicalities have generated $1.8 million in additional licensing revenue, money that funds Alzheimer's research at Johns Hopkins, Mayo Clinic, and 3 other prestigious medical centers. Edmund's vision of using his scientific work to help others continues expanding in ways he never imagined possible. The Edmund Ashford Foundation has become a model for inheritance-funded medical research. Legal scholars cite our case in articles about protecting testamentary intent against procedural obstacles. Estate planning attorneys recommend comprehensive documentation strategies based on lessons learned from our 2-year battle. But the personal satisfaction goes beyond money or recognition. Every morning when I review grant applications from researchers working on dementia treatments, I remember Edmund's voice from that hospital room. "Daniel, you've earned this. Your dedication deserves proper recognition." The Foundation's first major breakthrough came 18 months after our legal victory. Dr. Sarah Martinez at UC San Francisco, using Edmund Ashford Foundation funding, identified a protein marker that could enable early Alzheimer's detection 5 years before symptoms appear. Her research builds directly on theoretical work Edmund published in 1987, bringing his life's passion full circle through resources he intended me to steward. Victoria's legal career didn't survive her failed inheritance grab. Word spread quickly through Manhattan's legal community about her fraudulent complaints, harassment campaigns, and the $400,000 in unpaid legal fees that forced her former law firm into bankruptcy proceedings. She moved to Phoenix and now works as a contract attorney for personal injury firms, a dramatic fall from her previous partnership track position. The private investigator she hired to gather evidence against me ended up providing testimony that supported our case during the appeal process. His interview notes with neighbors, healthcare providers, and business associates painted a comprehensive picture of my appropriate care for Edmund and his genuine appreciation for my sacrifices. Margaret Santos, the home health nurse whose medical records helped validate the trust amendment, received the Foundation's first Caregiver Excellence Award recognizing healthcare professionals who document patient care with exceptional thoroughness and compassion. Her meticulous notes about Edmund's legal planning activities proved crucial to our victory. Mrs. Eleanor Hutchins, Edmund's neighbor who provided character testimony, became an unofficial Foundation ambassador, speaking at estate planning seminars about the importance of comprehensive documentation and witness preparation. Her stories about watching me care for Edmund through his final years bring audiences to tears while teaching practical lessons about family dynamics and inheritance justice. The Rodriguez precedent our case relied upon has been cited in 23 subsequent inheritance disputes across Florida, helping other families overcome procedural technicalities that threaten to override genuine testamentary intent. Legal reform advocates credit our victory with strengthening protection for legitimate estate modifications when standard procedures are interrupted by witness death or incapacity. The financial impact extends beyond my personal inheritance. The Foundation's research grants have attracted matching funds from pharmaceutical companies, government agencies, and other charitable organizations, multiplying Edmund's legacy by a factor of 7. His $4.6 million estate has generated over $32 million in Alzheimer's research funding through strategic partnerships and grant multiplication effects. But perhaps the most meaningful outcome was discovering a letter Edmund had written to me shortly before his death, found among his personal papers after the legal battle ended. The handwritten note, dated just days before the trust amendment signing, revealed the depth of his gratitude and the deliberate nature of his inheritance decisions. My dear Daniel, watching you sacrifice your career and personal life to ensure my comfort and dignity has been both humbling and inspiring. Your devotion represents everything good about family loyalty and human compassion. The trust amendment I'm signing today reflects my genuine assessment of your contributions and my desire to see you rewarded appropriately for your selflessness. If legal challenges arise after my death, please know that every decision was made with careful consideration and deep appreciation for the man you've become. Your character has been my greatest comfort during these difficult final years. The letter would have provided additional evidence during our legal battle, but finding it afterward felt like a final gift from the grandfather who'd shaped my character and values. His words confirmed what I'd always known. The inheritance battle wasn't about money, but about honoring the intentions of someone who'd recognized genuine sacrifice and wanted to reward it appropriately. Today, the Foundation occupies the ground floor of a medical research building Edmund's inheritance helped fund. The second floor houses a free legal clinic providing estate planning assistance to families who can't afford expensive attorneys, ensuring that others don't face the procedural obstacles that nearly cost me my rightful inheritance. The clinic has helped over 300 families create properly documented estate plans, with special attention to alternative validation procedures that can protect testamentary intent when standard methods fail. Every client receives a video recording system similar to what saved my case, along with training on comprehensive documentation strategies. If you're caring for aging family members, remember the lessons from Edmund's story. Document everything meticulously, record important conversations, maintain comprehensive medical records, and ensure all estate planning documents are properly executed with multiple witnesses and alternative validation procedures. Most importantly, understand that family members who show no interest in caregiving responsibilities often develop intense interest in inheritance distributions. Protect your loved one's genuine intentions with the same dedication you provide to their daily care. The legal system can be manipulated by expensive attorneys and procedural technicalities, but truth supported by comprehensive evidence has a way of prevailing when presented with patience and determination. Sometimes the fight for justice costs everything you have, but the alternative, letting greed triumph over genuine family devotion, costs something much more valuable: the integrity that defines who we are. Edmund Ashford's legacy lives on not in the money he left behind, but in the precedent his case established and the medical research his intentions continue to fund. One missing signature nearly cost me $2.3 million, but it couldn't diminish the love between a grandfather and the grandson who honored both his care and his wishes. The sound of morning coffee brewing in Edmund's kitchen still brings memories of our conversations about doing what's right regardless of personal cost. His voice echoes in every Foundation board meeting, every research grant we approve, and every legal clinic client we help protect their family's intentions from the kind of bureaucratic obstacles that nearly destroyed our own legacy. Sometimes the best way to honor the dead is to fight like hell for the justice they intended the living to receive. Victory tastes sweetest when you know you've earned it through sacrifice, persistence, and unwavering commitment to truth over convenience. From the Edmund Ashford Foundation, where one missing signature became the catalyst for protecting countless other families from similar injustice, this is Daniel Ashford reminding you that comprehensive documentation today prevents inheritance battles tomorrow. The most expensive legal fees are the ones you pay to recover rights that proper planning could have protected from the beginning. Drop a comment sharing your worst inheritance horror story. Your experience might help the next person facing family greed disguised as legal procedure. And don't forget to subscribe for more stories about ordinary people standing up to expensive legal manipulation and winning through preparation, evidence, and the determination to honor family legacy over family politics. You've been reading Inheritance Justice Stories, where missing paperwork meets thorough documentation and greed discovers that truth has a way of surfacing when someone cares enough to fight for it. The next story involves a stepmother who tried to steal her deceased husband's business using forged power of attorney documents, but forgot that his business partner was a forensic accountant with very particular skills in detecting fraud. That revenge gets served colder than Edmund's morning coffee, and you won't believe how it ends.